welcome back. This is Wake Up Sierra Leone here on AYV television and radio. Don't forget to add your voice to the conversation by dropping a comment, a question, or your opinion about the issues we're discussing, and we'll factor them into the program.
Indeed, drop those comments and questions. We'll definitely read them out in the show this morning. This morning, the Speaker of Parliament, yesterday, Dr. Abbas Chernobundu, ruled that a proper and explicit reference to the Constitution in the publication of the Gazette be made, and that on 12 June, which is the adjourned date, the Constitutional Amendment and the Public Elections Bill 2022 be enacted or rejected, even if it takes the House to sit the day and night. Speaker Bundu made that ruling after a serious exchange between the ruling and opposition members of Parliament on issues of following a proper procedure in the debating and enacting amendments to the Constitution. So this morning, to discuss this, we have with us in the studios Melvin Tijan Mansari, Senior Parliamentary Correspondent, and also lawyer Rashid, who earlier wrote a letter to the Speaker on the Public Elections Act. Good morning, gentlemen, and welcome to the show this morning.
Thank you very much.
Thanks for having me.
You're very much welcome. I'll start with you, lawyer Rashid. Before now, you wrote a letter to the Speaker of the House of Parliament, and that letter you were requesting to put on all the parliamentary proceedings regarding the proposed Public Elections Act of 2022 to allow for civil society input, wider consultations and education of the public. Just yesterday, the Speaker said in the next adjourned date, it could either be, passed or rejected. What's your point? I read what you wrote, but there's some legal issues as well that you raised. What are some of these issues that you're concerned about?
Thank you very much, AYV. We are grateful for the invitation, and I doff my hat to this media house. Anytime things are happening in the nation, you give us the platform, and that is how it should be. We are grateful for that. Yes, indeed. Many people were calling me yesterday when we had an unfortunate incident at Parliament again, and we understand one parliamentarian was pelted with a stone and was hospitalized, afterwards. People were asking, perhaps if the letter you wrote to the Parliament, Speaker, of course, but the Parliament as a whole, because I copied also the opposition heads, the clerk, and of course the AG himself. Maybe had that been taken in good faith, perhaps what happened yesterday would have been circumvented. Because all what we're trying to do as CSOs is to have a say, to have a voice in this whole epoch-making legislation. Because for the very first time, we've seen an attempt to amend the Constitution through a legislative bill. All right, so it's quite an epoch-making drive. And so we are concerned with some of the things we saw in the public elections bill of 2022. And so we were saying, okay, Mr. Speaker, can you please put a hold first in this whole proceedings and let the CSOs, the experts, the human rights people, the bar association, with legal expertise in some of these issues.
But there was pre-legislative hearing, before the bill went to the well, and that was even announced by the Office of the Clerk of Parliament.
Yes.
Inviting the public to come to the pre-legislative hearing.
So in my view, that is different, because we have been engaged with Parliament. It's quite different from calling for papers, calling for expert opinions, calling for critical reviews of this legislation, and allowing time at the very least for such reviews to come in, and then Parliament have an assessment on them before we proceed. So that is the missing thing. It's not about calling us or to sit down and hear what they are saying. No, it's about calling for, expert views, papers to be submitted, because it touches and concerns serious things that, will undermine, if not handled well, the peace of the nation. And there are many, many provisions in this public elections bill that we have seen that are very, very, draconian and may have, wide-ranging impact in our body politic, and even in our electioneering process. For example, I will give you one. There is the introduction of the NIN, National Identification Number, and under Section 13 of this law. And it now appears to me like a mandatory requirement, all right, for people to be able to register to vote. So it's a question that the public should know. What is this? Where is it coming from? Remember, NCRA has already registered people. And many people did not go through that process. So if you want to now make NCRA's process a requirement for next, electioneering process, having all the challenges that people have gone through, you are going to create a problem for voting and for, of course, the coming election. So let the public understand what you're trying to do before they go to that day to the polling station or to the polling center to register, and they are told that they cannot because they don't have a NIN. That might create a lot of rancor and problem for the peace of our nation. So don't rush this law. Let the experts have a say, call for public views, call for papers to be submitted, and let's discuss this. That's what we were calling for. But nobody heard it, and nobody is really making effort to do that.
With all those additions, especially you've mentioned the NIN, does that not suggest progression for the country? Or is that harmful to the democracy?
Yeah. So nobody is saying you cannot have a NIN number introduced. That is a separate ballgame for the NCRA process. It's awesome because NCRA may require you to have a number for certain services that falls within their mandate. But when you now want to extend that NCRA requirement to an electioneering process that is separate, you have to be very careful because the Constitution tells clearly who conducts the registration for elections, not NCRA, but ECSL, former NEC. That conduct. So you cannot now want to bring another institution's requirement into next electioneering process. That is the challenge. And from day one, it has been a challenge.
But shouldn't the goal be to ensure that every eligible Sierra Leonean gets NIN number, which, of course, again, is not impossible.
And people are still registering, by the way.
Exactly. That can be done from now to the election.
Yes. So here's what we... So if they had called for an opinion, I would have said, okay, you want to have this introduced. First, justify why. We hear the justifications. Now, we cannot have a law that has retrospective effect. Remember, we have passed the NCRA. I don't know if what you're saying is true, whether they are registered.
Yeah, you can actually go to
that has to be made formally open and known to everyone. That between now and the election period, if you have not gotten the NIN, you can come back and register, one. Then secondly, you don't need to make it a mandatory requirement. It could be one of the requirements. So there could be many things you will show to the person.
It is one. Yesterday, Honorable Abdul was reading it.
Yes.
It is one of the requirements, the NIN. The issue they have with it is, at the end of it all, the NEC will have to get their information, the data from NCRA for the voter registration.
Okay, maybe we might be misunderstanding things, but that's not an understanding of the law before me.
Yeah, but that was what they explained here yesterday.
Yes.
In one of the sections, that's the NIN is one of the requirements for registration. You can provide you can present other documents to register or your NIN number.
Yes. So that is not what is in the law.
Okay.
Yes, I have looked at the law. There is Section 13(1)(a) that makes it a mandatory requirement. There is Section 24 that says it is one-off. So we are saying, then if you want to have 24 as a one-off, then strike 13, which says it's a mandatory requirement.
But doesn't that in itself present sort of some advantages to the country when those who come to register would have an NIN number? For example, some of the things that Honorable Tawa was mentioning, issues of people coming to have multiple identity, the same individual multiple identity. So you are entitled to more than one registration, but with NIN, you can't duplicate it.
Yeah, so
that in itself is an advantage.
So what we are saying, it's not really about the introduction of NIN. But we're saying don't make it a mandatory, because now people have gone through challenges with NCRA. And then be careful when you bring NCRA into a constitutional created entity that is designed to conduct elections. It's not NCRA. So be careful when you do that. You have to amend first the constitution, perhaps the section that talks about voter registration being the duty of NEC. But then much more is we are coming at a time when we have passed, I will quote, passed the process of NCRA registration. I'm still not clear whether it's still happening, all right? But they have closed down that period. And many people did not go through that registration process, and we have learned as CSOs. So what we're saying, if you want to pass a law now that will have retrospective effects, you have to be very careful, because it's going to look back and perhaps stop those who could not produce one. So there are many ways you can identify somebody, you know, eligibility to register, all right, if there's a doubt. There are many ways. So NI could be one of the ways. Don't make it compulsory. That's what we are saying.
Because even with the normal registration, elections, voter registration process, there are always also challenges. But it doesn't prevent the process from continuing and the electioneering process from ongoing. So it comes back to why not better still introduce the NIN?
Yes. So remember, before now, there has been a lot of mistrust in bringing NCRA into the electioneering process. Let's listen to that backed up. All right. In fact, there was the argument that saying we're not going to register this, anymore NCRA data will be the wanted to. So a lot of mistrust exists regarding this whole two institutions coming together to exchange data. So, but we are saying the Constitution tells us who should register. So if we want to now shift to another institution to help, then it must be clear that the provision under the Constitution is amended. Otherwise, it will appear to be an interference of next mandate. And if we're going to introduce NIN, it will have been communicated before now, so that NCRA understands, the people of Sierra Leone understand that if you don't take this thing serious, there will be a NIN that will be, developed at the end of the day that will have to be a requirement for your voter registration. I'm sure if that had come earlier, at the period they were registering, the control would have been different. So that's the point. So now you bring it at the end when perhaps formally the process has been closed. So that's the concern we have. And then you're making it mandatory under Section 213. It's there. Under Section 24, you say it's one off, which was to me more sensible. But then why are you saying 13 that it is a mandatory requirement?
We're going to take a story before we come to Melvin that our colleague Joseph Johnson did yesterday from Parliament. But I want to ask, what do you think could have been the role of members of Parliament on this, and letting the public understand? Because I see your point is looking forward to, experts' opinions, the involvement of civil society, as well as the public to understand some of the things you're explaining now. What do you think could have been the role of members of Parliament from both sides?
I think we've done this severally. So it's not the first time Parliament have halted, the passing of a law and allowed for opinions and the public participation, CSOs and experts. I could recall the abolition of the death penalty law. I could recall the cybersecurity, legislation. So there was a lot of to and fro, and people were called, and eventually that pacified the whole process, and many things came out that they had to amend, going forward. And we are openly credited in Parliament. The Speaker called some of our names and thanked us for our input. That's what we are expecting also in this process, because it's about the country. It's not about politics or a party. There are many things now in that law, in that bill, that has to do with the Constitution. And so we cannot see or go through a process of passing a legislation that amends a Constitution without a constitutional amendment. It's a flawed process. I'm sure that is where the obstacle lies, because there are many things also that have been couched in this bill that are real constitutional issues. So, for example, the president now should have powers to remove the commissioners. It's in the Constitution. So if you want to amend that, you come with a constitutional amendment. You don't come with a bill. All right, so now
they came with some amendments. These are some of the things. But we'll come back to you, Lawyer Rashid. Quickly, let's take this story that was done for us by Joseph Johnson, who was in Parliament yesterday and saw it whole as it happened. Let's take that. When we come, we'll be speaking to Melvin Tijan Mansari as well.
The House was expected to continue debate on the Public Elections Bill of 2022, but that did not happen.
Quote unquote visitors, because these are not just visitors, Mr. Speaker. They are invited. I was insulted, my colleagues were insulted. In this chamber, it has never happened before. In addition to death, using invective, Mr. Speaker, we are not safe, we are not comfortable. Let the visitors leave us for us to continue to
Mr. Speaker, they have no empirical evidence to prove to us that these people in the gallery, I see them as Slovenians. I don't see them as belong to political parties. They are Slovenians. You want to tell Mr. Speaker, under the directives, under our leadership, are you going to take them out of the chamber? The people's house, the people's representatives' house, they voted this in out. They voted for us. If you are saying they can.
One side wants the gallery cleared, the other side wants the gallery maintained. The middle ground I'm suggesting now is we maintain the gallery on condition that decorum is maintained.
That was a short altercation on why visitors should leave or stay in the House of Parliament, but there was no headway, which made the Speaker stood the House down for 1 hour.
I will say that, Mr. Speaker. Mr. Speaker,
I stand the House down for 1 hour.
The sitting continued, but the debate on the Public Elections Bill never happened because of this.
But they are not convincing. But Mr. Speaker knows what I'm talking about.
I don't know.
Mr. Speaker, the documents they are claiming to have subsumed those that were the supplementary of the 28th of April 2022 is coming from a quote-unquote extraordinary gazette. Mr. Speaker, the Parliament is very clear. It's very clear. Let us don't circumvent the law to suit a specific purpose. We have all agreed, including the leader of government business, to uphold and respect the Constitution.
we need their votes. But Mr. Speaker, we need to tell this nation, Mr. Speaker, we need to tell the nation that the reason why we want to do the amendment, even if you're not going to get the 2/3, we want to explain to the people of this country why we want to amend provisions in the Constitution. Mr. Speaker, just for one publication, we have shown you extraordinary gazetting that has to do with the Public Elections Act. We have shown you supplement of the constitutional instrument. What else would they want us to do? If they are sincere, they really want us to discuss. As they demanded, let them allow us to say our bit. Afterwards, if you don't join us on this other side, we are not going to get the 2/3.
In the end, the Speaker made his ruling.
A proper and explicit reference to the Constitution in the publication of the Gazette. And second, is that at the next adjourned date, if it takes a whole day and night, so it shall be. But we will definitely complete our consideration of the constitutional instruments and the public elections bill before us on that same day. But these instruments must be passed into law or rejected by this House without further adjournment.
That opposing and the government bench MPs have done all they could to get what they want. But at the end, the Speaker's ruling has clearly stated that the right procedure should be done, not only to save his own legacy, but to save the country's constitution.
This might be Parliament's biggest test and live in memory, and it will arguably be an uphill battle to achieve the 2/3 majority to either enact or reject the Public Elections Bill of 2022. Joseph Johnson, AYV News, Freetown.
Well, welcome back. Thanks to Joseph Johnson for that report. Melvin Tijan Mansari is a senior reporter at Parliament, someone who's covered as well regional Parliament. Melvin, you saw it all yesterday. I know at some point you've been critical of parliamentarians and even the Speaker himself. But what's your assessment of how the whole situation was handled? Yes, how it panned out and how it was handled by the Speaker?
How it was panned out? Well, how it panned out was basically that due processes prevailed over what we call constitutional and procedural defects. And what's the ultimate game? The ultimate game is basically the House is in a stalemate. And we should understand the context. The context is basically hinging on the fact that in the Public Elections Act, proposed law of the Public Elections Act of 2022, there are certain sections that are proposed that are having bearing on also the Constitution, i.e. Section 32(1), which talks about the number of commissioners being increased from 4, and according to the government, it's as a result of we have new regions, and also Section 32(8) of the Constitution that talks about on what grounds should an electoral commissioner be dismissed. The new word is being introduced for gross misconduct, and that is having a constitutional bearing. But that's not also the case. I think the big elephant in the room is the proposed indirect attempt amendments to Section 76(1), 1A and B, that talks about no person shall be qualified to be a member of parliament if he or she is a naturalized citizen.
The TUSIM.
The TUSIM, the most talked about TUSIM. So it surfaced yesterday in another kind of fashion, and here was the opposition doing what they should do. We should say kudos to the opposition leader, and kudos to some of the fine lawyers we have also. Because had it not been for the legal mindset of the opposition leader, some of those things could have
come
passed.
to the legal issues. I want us to look at the situation where the opposition were saying, as you had in that story, they were not feeling safe about the strangers, as the Speaker called them, who were at the gallery. That situation, is it something that has been happening, that people can come to Parliament and be at the gallery and members of Parliament will think they are not safe because they are around?
It is worrisome trend, and this is not happening for the first time. We saw it happening some recent time ago, and some of us opined on it, saying that it is not, in fact, it defiles the sanctity of Parliament. It places the members of Parliament, including the public, at risk. Members of the public, according to the standing orders of Parliament, we are described, I use we, including journalists, as strangers who can be withdrawn at the whims and caprices of Mr. Speaker. What we've seen over time is that, well, the government bench argued that where is the proof? But the opposition was alleging that some visitors at the lower and upper gallery were being influenced to have a participation that is not warranted in the sitting. That is unprecedented, and I would advise Parliament openly to the public. It's a threat to their own safety, be you SLPP or APC.
But
we've seen a case of Joe Cox.
Naturally, people are allowed to go to Parliament and witness these proceedings, right?
Of course, but the intention and the agenda and the purpose for which they are there for should be guided. If not, we have no business in voting for members of Parliament anymore. If someone can sit at the lower gallery or upper gallery and shout at a member of Parliament, that defiles the sanctity of Parliament. Parliament is a sacred place. If you are going there, in fact, my opinion would be the House should restrict those participation to experts, diplomats, journalists, and citizens of no mean standing. I am not disrespecting the electorate, but had it been that everybody can have a say in decision making, then we're not having democracy in the first place. That's why we have representation. You must trust your representatives. So for what happened yesterday, let me state for a fact, even before the commencement of yesterday's 19th plenary sitting, before the sitting should commence at 10. Even before that, I was there 30 minutes or so before the commencement. There were mammoth number of persons, men, women, young people, at the lower and upper gallery, making snide remarks, firstly, against members of the opposition. And as the sitting progressed towards the end, it took a U-turn, wherein some sympathizers of the opposition also started responding to the debates. It's scary.
So it became a battleground instead of a parliamentary session.
Of course, and we should discourage any politician that is hiring people to come with an agenda to disrupt the business of parliament.
Whose responsibility is it to give clearance to members of the public to attend a
Well, I can
parliamentary
sympathize
session?
with the House that they want to make it an open parliament, because this is the modern
Because that
thing.
was the argument of the leader of government business yesterday.
Not just about the leader of government business. This is the trend across parliaments all across the world. Citizens must be able to access their parliaments, must be able to access information about their parliament, must be able to access their parliamentarians.
But through whose office do they make it
Now,
to the sitting?
upon visitation to parliament, there are special cases. If it's on a state opening, it's strictly by invitation. That comes from the administration of the parliament. If it's on a normal sitting, you only ought to have your national identification card or some means of identification as a citizen who's got the rights to follow proceedings of parliament. So the House is in a slippery slope. But what I think in this situation, yes, we want everybody to participate, but they must not be motivated.
I asked expecting that there are at least guidelines as to the citizens who can come and participate in the process.
The guideline is every citizen should be, and as it stands, are allowed to visit parliament on normal occasions. On special occasions, such as state opening, it's rare. And that brings us to the issue of that Rashid is raising, call for papers. When you have pre-legislative hearings or some public hearings, Parliament can extend invites to expert organizations, individuals to come and visit. But I think what we need here is those persons. We need to tell the truth to the politicians. I will tell you, those persons were not there by themselves. I spoke to people that came from Kono, some people came from Bonth, some people came from Makeni. Who do you think mobilized those people? It's our very own politicians. Now I'm telling them it's at their own detriment. There is a precedent in the UK, the killing of a member of parliament that is called Joe Cox. Follow the debates that led to our killing. Parliament should be a place of security. And that's why we have the Sergeant at Arms Directorate. I think, yes, yesterday they did their best, but they must advance their skills in crowd control. They did their best. In South Africa, they're having the security protectorates for the parliament. Then these are security people. So we must do more. But yesterday, you cannot divorce the blame from the SLPP and the APC, particularly the SLPP at first, and later the APC, for mobilizing those crowds at the gallery and making all kinds of unparliamentary conduct.
Melvin, let's look at the stalemate already in Parliament. If this continues in the coming sittings, where does this leave the Public Elections Bill 2022?
Rejected or accepted, but there is a catch. The fact of the matter is, it's not about the Public Elections Act, it's about the proposed amendments to it. That, again, kudos to the opposition, APC, for raising the flag. That you cannot come and with a bill that seeks to amend the Constitution without coming with a constitutional instrument to amend the Constitution. And again, thankfully to the SLPP, the leader of government promised that they will come with it yesterday, and they did. But unfortunately, the stalemate is about the publication on the Gazette. It says it should be published 2 times with separate days of 9 days apart. And I think that's where I will want to condemn, I don't want to use condemn, but to blast the Attorney General's office. That office must be competent enough. I have watched from the public, from the state of emergency, how that office blundered, and it seems as if they are consistently blundering. They are misguiding the executive. They ought to do due diligence before presenting these things to Parliament.
Melvin, continue to hold your thoughts. We'll come back to continue the conversation. It's 8:45 and it's time we take a quick commercial break. Stay with us through the break and we'll come back to continue the program. right, welcome back and thank you very much for staying with us through that break. This is Wake Up Sierra Leone here on AYV Television and Radio. Remember to add your point to the conversation. Just log into our Facebook page, AYV Sierra Leone, and drop a comment. Melvin, before we left off on that break, you were raising concerns about the role of the Attorney General's office in all of this. Where did they fall short?
It seems as if they are overwhelmed. And when this government, I mean the new direction of SLPP under President Madabio, promised to unbundle the Attorney General and Justice Ministry, some of us were very happy. I'm not a lawyer, but I'm conversant with the issues that are facing the judiciary. It seems as if they are not profiling what I will call the right advice to the executive. For God's sake, this is a matter of consensus, that's one. It's a matter of consultation. I vividly recall when the matter was first brought to Parliament in a pre-ledge, the leader of the opposition expressed concern that when the NEC Director of Legal Affairs had wanted to make some explanations, he said, quote unquote, to INE consult, because the opposition themselves, in as much as partly they will disagree with me, I think they want to filibuster the bill because of its...
That is what I wanted to ask. Because even at the point where the Speaker assured of their security, even the leader of government business assured of their security, the Speaker even spoke clear to the people and told them that if they cause any noise, they will be asked out. And he gave them that several assurance, but they were still insisting that they are not safe and the people should go out.
No,
and they spent over 1 hour on that.
In as much as I will commend Parliament, the Sergeant-at-Arms Directorate, for removing some people from the gallery that we are very, very irritant, if I'll put it, but that was not enough. I will tell you as a journalist, yesterday was not safe for even us as journalists. Let's talk about members of Parliament. Let's talk about even the gallery. Had we seen a fight between the gallery? We could not have contained that. The police were professional because they don't wanted to invade, because we criticized them for that. But I will tell you, we need to up the game for the Sergeant-at-Arms, improve their capacity, particularly in crowd control. But back to the issue you raised on the fundamental disagreements at the Justice Ministry. For God's sake, I think what we saw we thought that Priscilla Schwartz was not a good Attorney General, right? So many of us. In fact, that was very unfortunate. It was gender insensitive. We saw the new man came in, who was later removed for the new person, with regards to the state of emergency. There were no rules and regulations for that. Who do you blame for that? You don't blame Parliament, you blame the executive. So for me, I think the Justice Ministry, President Bio, he must surround himself with the right lawyers. And not lawyers who can only explain law, but can explain the moral side of the law, which is the fact. And for what we see now for the gallery, I think moving forward, we need more security. It was not safe. The opposition might want to filibuster, but they are using what I would call traps on the procedures and the laws, and they are catching the government in these traps, unfortunately, as a result of what I would describe as the weakness of the Justice and Attorney General's Ministry.
As we try to round up this segment of the discussion, Lawyer Rashid, you know, we have constitutional amendments that are in front of Parliament on certain. It has to do with, one is about boundary delimitation, and I've forgotten the other one that the Attorney General laid yesterday. There is also the Public Elections Act. At this time, with all what is going on, what do you think needs to be done, you know, to have a situation where, you know, we'll have something that the public will understand what it is about, and Parliament itself will do their own work?
Yes, it's a good question you've asked, and I understand the constraint, and even us, when we're looking at the bill, it's a quite bulky one. You'll notice that there are a lot of things inside there. So let me attempt to make one or two inputs quickly to the things that are there. Change from constituency elections to proportional representation. Introduction of the NIN as a requirement for NEC registration. The power to extend voter registration even after the period of registration. So NEC will have power to sit down and say, okay, you know what? After they've closed the registration process, they think, okay, one area is still in our assessment deprived. We can still open it again for that particular area. I don't understand where that is coming from. The president will have powers to remove NEC commissioners for gross misconduct. The age of NEC commissioners to be 65. Change of a PPRC to regulatory commission. These are all things that also are surfacing now in Parliament. The next commissioner to have power to cancel elections on the ground of violence. See now, allowing holders of dual citizenship to be qualified to vote, vote for as members of Parliament. These are all constitutional matters. So you can see the issues. So what we are going to do, and at this again, I don't mind spending one whole week on this. My organization, we're going to do a critical, step-by-step legal. No, look, God, this hour has given some of us to help the nation. And we are going to do this with peace and joy. We are all politicians. We're going to do it for the people of Sierra Leone. They've hidden a lot of things here. My organization is going to do a thorough legal opinion, word by word, step by step, and expose it
to Parliament,
to the entire nation to see what is in this bill and the implications of everything they want to do, both constitutional issues and non-constitutional issues, and then let Parliament now go and do what they want to do. So our hands will be clean to say there was a voice in the land that raised this thing up. When they go and do what they want to do tomorrow, posterity will judge that we are on the right side of history.
You have a tough race against time now,
yes.
Considering the speed at which Parliament is working on this. What happens?
I have the best, and trust me, God will give us grace. We will sit down from today, and I'm sure by Friday or over the weekend, we will release our...
Because my concern is what happens if, they're done and over with the entire process before you're done.
Yeah, so first we have an obstacle here, and I'm happy the speaker had adjourned, because they had to do the gazetting, and follow the procedure. Maybe that is a blessing in disguise for us to now work on and expose everything to the public to see the implications. And then send to Parliament as well. So that, because I know, again, look at me, this is the challenge also I'm having in Parliament. The truth is this: many of parliamentarians don't read. That is the truth, and it's unfortunate.
Because they don't have researchers.
Yes, so again, yes, perhaps going forward, we should have them have researchers to help them, legal researchers. Because this is about law. You have
Parliament has a legislative committee, right, Melvin?
Yeah,
they have legislative committee.
Yeah, but the number of staffs for that committee, for a legislative committee, Parliament is not having a directorate of legal counsel, which according to the Parliamentary Service Commission Act, it should be there. And that's why we're having all of these legal embargoes all going on around.
So we're going to help the parliamentarians.
Let's take some messages.
And take one by one all of these things.
Let's take some messages.
Yes.
The first one I'll take is from Alusain Sherif. He says, your discussion is not allowing members of the public into Parliament is immature. Why must the general public be stopped from hearing in the well of Parliament? That discussion should not hold, and it's not debatable.
Louis Man Bekus says, brother, if that's their intention, then too should be made very unfunctional, period. They got to learn to accept defeat before they can win any election.
And Mohamed bin Nyale says, if a House of Parliament is always under chaotic happenings, I wonder how decisions are going to be objective for a better Sierra Leone. It's just like the father and the mother in a home. If they're together, they are said to be peace, but if they're not, the otherwise happens. They are on a sorry for you.
Victor Akomengot says, kudos to the Speaker for directing the House yesterday on the rules and procedures of Parliament, especially matters relating to constitutional amendment and the proper laying of bills and statutory instruments in the well of Parliament.
And he went on to say, Victor Akomengot, I'll read again, he says, people can attend parliamentary session, but must respect the rules of procedures, as the Speaker said. They must be seen and not heard.
Asiatu Mansaye says, these leaders are not serious to bring peace for us to citizens, but God will surely hold them accountable for misrepresentation.
I'll read this one from Liz Manbakus. It says, Melvin doesn't seem to be neutral at all, and what he's saying makes no sense. It is the people's parliament, for Christ's sake. So how can he advocate for the stopping of the people from attending parliamentary hearings?
Abraham Father SL says, all the things that are happening tells you that we're not even safe again in this country, because even the well of Parliament, that's supposed to be a sacred place, is now an environment for thugs.
And Dauda Tawali says, until our Parliament pass laws that are beneficial to the nation rather than for the party in power, the country will never improve. 61 years, we are still looking for water and electricity.
Roosevelt Rose says, why the establishment of state institutions like the NCRA? Why the NIN number for account opening, passport and other relevant documentations, but must not be applicable for election registrations?
The final one I'll take is from Yoki Musa. He says, our country is 62 years now, no better development, always scarcity of food, commodities, fuels, and citizens don't have rights in their country, giving parity to the foreign people in this country.
And Christopher D. Sharif says, most of the CSOs in this country are the principal architect of all the unrest that's currently happening in this country. They incite the public on pertinent issues that will change the lives of citizens by misinterpreting the confused and haphazard constitution that we have in this country.
Okay.
Gentlemen?
Yes, those are the messages. As we try to round up, Melvin, what should we expect on the next adjourn date?
Well, if they use the long adjournment period to do bipartisan consultation and consensus building, I think we don't need to stay in Parliament for the whole of the night. People must be, I mean, of course, I am a proponent of open Parliament across Africa, not even in Sierra Leone. I believe they must, but again, we must be very careful when the people are manipulated by politicians, then our parliamentarians and every one of us are not safe. And that's my position. We must screen the people that go to Parliament. We don't need to go and take rally boys elsewhere just to obstruct the process of Parliament. We are disrespecting our votes, and that's my position on that.
Finally, should we expect the process to be, moderated the right way on the next adjourn dates? And like the speaker said, it's either be passed or rejected. Should we expect that to happen?
It's uncertain, but I think the process is so far on the right track. There were defects identified by the opposition, and they have been ordered to be corrected by the speaker. Kudos to him. That was matured of him, and that was non-political, though he's a politician. And I think, should we expect a solution? It's uncertain. The facts hinging on the fact that 2/3, you will need 98 votes. No APC, no SLPP, no NGC, no MPC MPs have that number. So it needs political consultation. Unless that is done, I'm afraid it's not going to go through.
So, Rashid, we should expect the opinion, the paper, the professional opinion on this from you.
Yeah, that's our commitment, and we'll do our best to making sure that it's done before the next adjourn date. That's our goal.
Thank you very much, gentlemen. Melvin Tijan Mansare and Lawyer Rashid for joining us this morning to discuss this issue. This is a discussion that will definitely continue because it's very important as we move on to elections.